Thank you, Your Honor. May it please the Court, I'm Sylvia Walbolt, and with me at counsel table is my partner and trial counsel, Mark Brown. I'd like to reserve 3 minutes. And I'd like to start, Judge Padovano, with your question of how is the plaintiff going to prove who was wrongfully charged the original rate. And what you didn't hear in answer to that question, Judge Padovano, I'm not issuing a challenge. I'm just making an observation that what you didn't hear was that the Higgins proof that they were wrongfully charged the original rate would prove that for all of the 320,000 borrowers in this putative class, or that it would prove it for any other borrower. And you didn't hear that because that's not the case. And that's not the case because there are two rates that can be lawfully charged in a refinancing transaction. The original rate can be lawfully charged to certain borrowers if they don't satisfy the conditions for the reissue rate. The reissue rate can only be charged to those persons who do satisfy those conditions. And so to prove that a person was wrongfully charged the original rate, as the Higgins say they were, they will have to prove for each and every borrower in the class that that borrower satisfied the conditions of the reissue rate, all of the conditions that Mr. England previously discussed with you. And that's going to be a highly individualized inquiry. They've already gotten us ordered to produce 320,000 files, closing files, to go through those and see if there was a qualifying policy in them. But we know that even if you looked at each and every of those files, Judge Roberts, in many of them you will not find a policy, any policy at all, much less one that necessarily qualifies. And so then you have to make an additional individualized inquiry. And in this case, the plaintiffs, the Higgins, came forward with proof adduced by their counsel in their deposition that although they weren't told of the existence of the issue rate, that had they been, they would have come forward with their policy. So for every borrower who, after we've looked in their file and we see whether there is or isn't a file, and the vast majority of them, there is not going to be a policy in the file. And we know that from the file sample that the plaintiffs themselves relied on in this case. In the vast majority of them, there was not a policy in the file. So in that instance, you're going to have to come forward with proof, just like the Higgins did, that yes, they did have a policy, yes, it satisfied all of the conditions of the reissue rule, and yes, they would have come forward with it so that it could be put in the file as is required in the rule. And that is what the mini trial will be. It will be a mini trial, just like we had for the Higgins, to come forward and prove they could have satisfied those conditions. And it's that that makes it wrong to certify this class, because this court and every district court in Florida has said class certification is not appropriate unless the named plaintiff's proof of their own individual claims will, quote, necessarily prove the claims for each one of the members of the class. And I want to call the court's attention to the 4th District's decision in the Porsche case, because the 4th District made exactly the point, Judge Padovano, that you made when you started by saying, how are you going to prove who was wrongfully charged the reissue rate? Porsche involved a claim that Chase Manhattan improperly charged the plaintiffs a late fee on their mortgage payment, even though they had gotten the mortgage payment in within the contractual grace period. And the 4th District said that the named plaintiff's proof that they were wrongfully charged a late fee because they, in fact, got their payment in within the contractual grace period, wouldn't prove that any other mortgagor was improperly charged the late fee, because you would have to know, did the other borrower get the payment in within the grace period or not? And the Fourth District said, and I really commend this decision to the court, because it's a very careful analysis, and it does rely on First District precedent, including the Ernst case. And the Fourth District said that this was a liability issue, not just a matter of damages, as is the case here. And it said a single individual issue will predominate, namely whether each individual borrower's payments were received within the grace period. And that's exactly what the case is here. The individual issue that will predominate at trial. We're assuming duty will have been resolved on summary judgment. We know duty is a legal issue. The court's going to resolve that.
Well, if the duty is if someone has one of these policies, it's the title insurance company's obligation to apply the discount.
That's correct.
In all cases.
That's correct, Judge.
Why is he not right on that? It seems like if he prevails on that issue, on that very strict definition of what the statute requires, that this might be a class. That there's not individual proof other than, did this person have a prior policy? That's the only issue that you have to establish.
No, Your Honor, because you still have to have a determination to prove liability that Commonwealth breached its obligation for those borrowers, that Commonwealth or its agent didn't make the disclosures, didn't make the efforts. And in the mini trial that we will have, where we will show for many of these borrowers that Commonwealth did every single thing that the plaintiff says should be done. They checked their database, they asked the borrowers, they called the prior agent, they did everything that a human being could do to find out if there was a prior qualifying policy, and weren't able to locate it. And so that's going to be the predominant issue, just as in Porsche. It's the exact same parallel. In Porsche, the plaintiff was going to have to prove that they had satisfied the conditions for having the late fee excused. They got it in within the grace period. In this case, they're going to have to show that not only do they have a policy, but that the policy qualified for the rate, and that it was obtainable by Commonwealth. The reissue rate says the rate cannot be charged. Cannot. It's mandatory. It cannot be charged unless a copy is in the file. And so that for every borrower, there's going to have to be an inquiry, and it'll be individualized, just like the Higgins. The plaintiffs adduced proof that the Higgins, had they known about it, would have come forward with a policy. They're going to have to do that for every single other borrower in the class, and that is what is going to make this an unmanageable trial with a predominant issue of what breach is. It's not simply defenses, although that's going to be very individualized as well. It's the question of breach. Did Commonwealth breach its obligation to charge the correct rate? And the plaintiff's proof that we may have breached our duty to them, again, and proof that it isn't going to be even just from looking in their file, Judge Roberts. You asked the question of Mr. England about practices of sending policies into the file. In the Higgins, their prior policy wasn't written by Commonwealth. It was written by First American. So it would never have been in our file. We would have had to go and take other steps to see if it could be obtained. And that is my answer to the question that counsel posed about the standard of review. We believe that this certification order must be reversed because the trial court did not find, and the trial court could not have found, that the plaintiff's proof of their claims would necessarily prove the claims of all class members. And this court has repeatedly said, unless that's the case, class certification is inappropriate. And that's just a question of law. Likewise, this court has said that the trial court must envision how a class action trial would proceed. And again, duty is going to have been resolved one way or another on a summary judgment. And then the question will be, did Commonwealth, for each of these 320,000 borrowers, breach that duty? And the trial court didn't address that. And the trial court acknowledged that it didn't address it. It said, I'm going to take duty as a first step, and then I'll worry about these other issues. But that's not what this court has said that trial courts have to do. And if that were enough, if that were all you had to do to get a class certified, is to come in and say, here's an issue of duty, then I submit lots of cases in which this court has said class certification was improper, would in fact have been certified, because you would have said there's a question of duty. Should Chase Manhattan, did it have a duty to comply with its contractual provision that it wouldn't charge a late fee if it got in the grace period? Common issue for everybody. But the question is did it breach it for particular people? The plaintiffs have acknowledged in their brief, at page 34 of their answer brief, that proof of the existence of a qualifying policy is going to be an individualized issue. This is not a case like Powertel or Paladino, where if the plaintiffs were wrongfully charged a fee, everybody was charged a fee, where if a contract was wrongfully applied for one, it was applied wrongfully for everyone. Thank you. I'll reserve the rest of my time.
Haven't gotten to do rebuttal as an appellee before. My sister's absolutely right. You're supposed to envision how is a trial going to proceed if class certification stands. That's what the judge did. That's what Judge Davis did. And he said this was the first step. And Judge Roberts, you get it. You're right, exactly right. The first step is motion for summary judgment. Here's how it will proceed. Motion for summary judgment. The plaintiffs will file a motion for summary judgment. We will attach one thing to our motion for summary judgment, and that is the owner's policy. We're not going to put any facts on about they knew it or we knew it or they told us. None of that's going to be relevant. It's going to be a motion for summary judgment that says we got a policy. Under this rule, we were entitled to the reissue rate. We win. If we win that motion for summary judgment, there's no trial. There's no trial for us. There's no trial for any class member. Whether there was disclosure, whether somebody said, I don't want to go through the trouble of digging one out, whether any of those things happened become irrelevant. There are no individual issues. Winning on that motion for summary judgment, it's more than just duty. It says that anybody with the policy gets the reissue rate. The only question is who has the policy. Well, that's the definition of the class. If you don't have the policy, you're not in the class. So there's not going to be a mini trial on whether any individual has a policy or not. Either there's going to be a policy that we can all look at and say, here's the policy, what are we going to have a trial on? That's not really a policy. There'll either be a policy or there won't. So the key that's going to come to Judge Davis is this strict interpretation.
And if you don't win on the summary judgment, then what happens?
It's going to depend on why we don't win.
Well, that's kind of getting into their argument now, I think, is maybe if you just assume for the moment that maybe the law doesn't require a categorical duty on the part of the title insurance company to provide this discount, whether they're aware of it, whether they've been told, whether they could find out, whether it's possible to find out, whether there's any way they knew or could have known, they owe the money because, in fact, the landowner can produce a prior owner's policy. If that's the law, the case is over with. But if it's not, then aren't you walking right into the problems? I mean, if it's something less than that, let's say, Are
No,
you
it
not walking
depends.
yourself right into the problems that Ms. Walbolt has described?
Sure, we might be, and at that point, the common issue will have been resolved, leaving, depending on how it's resolved, leaving maybe too many individual issues to try. You decertify the class. All of the members of the class are bound by that determination, and they're going to have to do more than just show their policy. They're going to have to do whatever it is that First American prevails and shows was required by the borrower to do. But, you know, in their strictest sense, their argument is this. The statute says we have to have a copy in our file, and let's just look in the file, and if there's no copy there, you don't get the rate, even if we didn't ask you.
I understand the point you made earlier about not deciding merits issues in the class certification, and of course you're right about that, but it seems like these issues are connected to me. And does one issue not have a bearing on how the class is defined?
It does, and you're right, and they are connected. But that's why
it would seem to me to be a lot more practical to figure out the answer to this first question. If in the broadest possible sense the judge is right about this, you know, this duty, then there's no impediment to class certification at all.
But that's why, Judge Padovano, that's why the state rule and the federal rule say you don't have class actions as to the whole case necessarily. You can have a class action as to an issue, okay? And this is a class action as to an issue. If we prevail, it's as to the whole case. If we lose, then that issue has been resolved on a class basis, and the resolution of that issue may mean that continuing as a class is impossible. If they just win based on whether it's in the file or not, then there's a subclass that prevails, the subclass of anyone who it's in their file. We've done their file review, and about a quarter of their sample files had owner's policies sitting right in there, and they didn't charge it. So even if they prevail on that issue, some people are going to, in this class, are going to prevail on the merits. And I think it's important for us to return to what is Judge Davis going to have to do. He's going to have to interpret a statute. The interpretation of that statute will decide this case. It will either say it was appropriate as a class going forward, or it was appropriate to resolve this issue on a class basis, but now going forward we're going to decertify. That issue is interpreting some pretty plain language, and I'd just like to, I think we need to look at that language. It's in the statute, it's in the rule, it's the same language. It says, provided a previous owner's policy was issued, ensuring the seller or the mortgager in the current transaction, and that both the reissuing agent and the reissuing underwriter retain for their respective files copy of the prior owner's policy, the reissuing premium rates in paragraph A shall apply to mortgage policies issued on refinancing a property insured by an original owner's policy, which insured the title of the current mortgage. There's nothing in there that talks about disclosure or presentment or waiver. It says shall. And many of the cases that we cite say, you know, we're not going to decide the merits right now, but my gosh, if you look at the word shall, that's a pretty direct command by the legislature. How are we going to get around shall? But that's what the judge is going to have to determine. And they have this creative argument that this requirement that the policy be retained in the respective files, that is something that if they didn't retain it in their files, they don't have to charge the reissue rate. Well, we think that's wrong, and we think we can show that that's not what the plain language of the statute requires. But that's a merits determination. And again, it's very important. This happened in Engle. I cited a bunch of federal cases. This is happening more and more, where you have class certification as to an issue. In this case, the issue, we believe, is case dispositive. If we win on this one issue, the case is over, and all it is sending out the money.
It could be dispositive.
Well, yeah, it could be dispositive. And that's exactly when an issue, as opposed to a whole case, is appropriate for class certification. It could be dispositive. If we win on it, it's dispositive. If we lose on it, depending on how we lost, either subclasses are going to be necessary or decertification. And if they're right that you had to present the policy, then it's going to have to be decertified. That is not the same as saying, the judge saying, oh, I shouldn't have certified this in the beginning. Now we see it was a mistake. That's not what would happen at all. Then you say, well, it's a good thing we certified this, because now all of these class members are bound by this legal determination. This has been resolved as to everybody in the state of Florida that it applies to. And now we're going to decertify going forward. That's not denigrating the earlier decision. That's not saying we made a mistake earlier. That's saying that the result applies to all those people. And because of that result, it no longer can proceed as a class action as to some or all of them. That's why the rule provides for certification as to issues, and this is a perfect example.
How
of a
are you
case
going to
where-
find these people to give them notice?
Well, a lot of them, it's going to be real easy, Judge Padovano, because when we got their sampling of files, the policies were sitting in a whole bunch of them. So that's pretty easy. Others of them, it's also pretty easy because although the policy wasn't sitting there, there was a reference to the policy. The title number on a deed, some correspondence, a HUD statement. Often these HUD statements will say right on there, you'll have a notation of it. So in many cases, it's very easy. In other cases where you don't have all of that, then there's going to need to be some administrative work done. There's going to need to be, the first step is probably to call, ask the individual borrower, did you have an owner's policy? Just like they said, just like Ms. Cahill, the affidavit. She said she did all of those things. Well, if she did all of those things, then probably there's not going to be anybody that bought a policy from her that had an owner's policy. And so they're not going to be any class members, so we're not going to have to worry about that. But we're going to do the best that we can through discovery, through whatever means are necessary. Again, most of the time it's just looking at the file. But if we go forward with that a little bit more, we'll find as many of them as we can find. And any of the ones that we find are going to get the refund. And if we can't find it, there may be some out there that you just can't find it because it's just not, quote, humanly possible. Well, if it's not humanly possible, then there's not going to be a mini trial as to that person. There's only going to be a claim if there's a policy. If there's a policy, they get paid. If there's not a policy, they don't get paid. There's no trial on that. That's just finding if there is one or not. And it may be that at the end of the day, there are some people who are entitled to refunds who won't get it because we could never find evidence of that policy. But in class actions, as in life in general, we cannot allow the perfect to be the enemy of the good. And we're going to find most of these, and they're entitled to their refunds. And the complaints, I want to return to one thing. The complaints about how hard it would be to do that, they should ring hollow to this court. It's just like somebody who kills his parents begging for mercy because they're an orphan. The reason it's going to be so hard to do these hundreds of thousands of times is because they didn't do them in each individual case. Had they done it in each individual case, this wouldn't be an issue. And again, you have to conclude that Judge Davis did what no reasonable judge would do. You would have to conclude that Judge Northcutt, Judge Altenburn, Judge Kazam, 4 trial judges, all did something that no reasonable judge could do. You would have to conclude that the Fifth Circuit Court of Appeals did something that no reasonable judge could do. Mr. England cited the Hancock case in his rebuttal. The Hancock case is out of the Texas District Court. It was decided on the exact same day, August 9, 2010, as the Mims case. So while one trial judge in Texas might have said, oh, these problems, I don't want to have a class because of these problems of identifying the class members, his appellate court that same day said that his brother was not unreasonable in finding to the contrary. And you should do the same thing here. Judge Davis had wide discretion. He looked at this. He looked at the trial plan. He determined that the first step could end this case, and let's go to that first step. First step should be done as a class action. Let's see how it's resolved. And that's not an abuse of discretion. Thank you.
Thank you.
Very briefly, summary judgment on duty would not be dispositive whether they won or whether they lost. There's still going to have to be a determination of whether Commonwealth breached its duty. And that's going to be the individualized inquiry of whether there was a qualifying policy, whether it was ascertainable. Now, what I think I'm hearing Mr. Mills say is if, in fact, we prove for various borrowers that that wasn't the case, then they drop out of the class. They're not bound at all. But that's not the way a class action works. And that is the fallacy of Judge Davis didn't think about how a class action trial is going to work. He's made the summary judgment of what the duty is. Now we're going to have a trial of who was wrongfully charged the rate because we breached the duty that the court has found. And that's going to be a highly individualized issue. And we know that because the Higgins themselves had to come forward with proof. And it was proof in addition to the fact that they had a qualifying policy. It was proof that they would have come forward with that policy so that it could be placed in the file. That's not a creative argument by counsel. That is a requirement of the rule, and it can't be rewritten out of the rule, as the plaintiff would like, simply because it creates an individualized issue. I again commend the court to pages 8 and 9 of our brief, which were not responded to in the answer brief and haven't been responded to today, where we took even the very limited sample that the plaintiffs themselves had come up with and pointed to a sample that began with some 290 files. They had to throw a bunch out because they were, quote, incomplete or unreviewable. And then of the 194 that were left, they were all over the place. A few did have a policy in the file, and it should have been charged, no question. But the vast majority of them had nothing in the file to suggest it was wrongfully charged. And in fact, over half of the file sample, the plaintiffs themselves acknowledged. It appeared that it was a correctly charged rate, the original rate to those people. So this is not something where you can simply say we're going to look at the narrow issue of duty as a first step. You have to determine how would this case proceed as a trial once the 320,000 files have been produced. Thank you, Your Honor.
Thank you, counsel. And thank you to all counsel from the court for excellent arguments this morning all the way around. We appreciate that. Court will be in recess until next week, I suppose.